itself to the dissipation of sound. Horsted House is 700 metres away, but the sound is clearly audible. Our garden is filled with noise, and you cannot get away from it unless you go inside and close the windows. It would not be so bad if these events happened in the winter, but in summer it makes it difficult to get to sleep. If you extend the licence, there will not be a single Saturday to enjoy the peace, because 18 days would licence the Bluebell Railway to disturb every weekend all summer. 18 days equals 4 Saturdays a month for 3.5 months, i.e. from the end of May until mid-September. Mr Paul has made objections on the ground of the prevention of public nuisance. Mr Paul is present to speak to the panel, so I will summarise his representation. He has stated that the increased area of the application includes the paddock next to the adjacent residential cottages, which are the railway cottages. He states they've previously held weddings and events there, and the noise and disruption to residents has indeed constituted a public nuisance in the past. The events involve loud music, which penetrates the cottages, and the increased frequency of the events will simply cause even more public nuisance by way of noise pollution. On a weekend band event held in the field opposite the station about a year ago, the noise disturbed people over a mile away. He states that the application would take things to a whole new level of disruption, anxiety and stress, and that the events they wish to hold would seriously and detrimentally affect their quality of life and health, and that previous concerts and weddings have produced an unbearable level of noise pollution and penetrates all of the cottages. Mr Jake McQuitty has made objections on the grounds of prevention of public nuisance. He's unable to be present at the meeting to present his objections, so I will present them on his behalf. He has stated, in short, we object to any licence that results in an excessive number of events at the station and environs, and which are liable to run late into the night with live bands and crowds of people creating significant noise that can be heard from our house. Our children will be kept awake for a start, but more importantly, this would constitute a public nuisance. Mr Rufus Clark, again, who is unable to attend the hearing, has made representations on behalf of himself and 3 family members. He has stated that noise emanating from the premises has been experienced from previous events held at this location. This has resulted in our family being unable to sit outside or have windows open in the summer months. Previous events have resulted in loud music and excessive noise from attendees at the event, which has caused disturbance for an entire weekend and as such caused a public nuisance. The likely effect of granting a new licence will be increased disturbance and restrictions to our peace during afternoons and evenings, when we should be keen to be outside in the garden. Keeping our windows open has been problematic during these events, as the sound has affected our children when trying to sleep. The full representations from all parties are attached to the appendices to the report for the benefit of the panel. The policy context is the committee must determine the application in accordance with the Licensing Act 2003, the Mid-Sussex District Council licensing policy, and the guidance issued under Section 182 of the Licensing Act 2003 by the Home Office, whilst having due regard to the applicant's submissions and relevant representations. I have set out Section 18 of the Licensing Act, which deals with the determination of the application. I don't propose to go through each step of that particular section, as the panel has your legal advisor present who can advise you as necessary in respect of it. At 21, relevant representations. The Licensing Act of 2003 requires representations to address the 4 licensing objectives, which are the prevention of crime and disorder, the promotion of public safety, the prevention of a public nuisance, and the prevention of harm to children and young persons. A representation is a relevant representation if it is about the likely effect of the grant of a licence on the promotion of the licensing objectives. The objector must establish that such a consequence is a likely effect of the grant, i.e. more probable than not. I think it'd be helpful for me to point out to the panel the relevant parts of the guidance issued under Section 182 of the Licensing Act. Where a representation concerning the licensing objectives is made by a responsible authority about a proposed operating schedule and it's relevant, the licensing authority's discretion will be engaged. It will also be engaged if another person makes a relevant representation to the licensing authority which are not frivolous or vexatious. Relevant representations can be made in opposition to or in support of an application and can be made by any individual, body or business that has grounds to do so. The guidance goes on to say that a representation is relevant if it relates to the likely effect of the grant of the licence on the promotion of at least one of the licensing objectives. And it goes on to say, for example, a representation from a local business person that commercial damage would be caused by competition from a new licensed premises would not be relevant. On the other hand, a representation by a business person that nuisance caused by the new premises would deter customers from entering the local area, and the steps proposed by the applicant to prevent that nuisance are inadequate would be relevant. In other words, representation should relate to the impact of licensable activities carried on from the premises on the objectives. As a matter of practice, licensing authorities should seek to focus the hearing on steps considered appropriate to promote the particular licensing objective or objectives that have given rise to the specific representation and avoid straying into undisputed areas. A responsible authority or other person may choose to rely on their written representation. They may not add further representations to those disclosed to the applicant prior to the hearing, but they may expand on their existing representation and should be allowed sufficient time to do so within reasonable and practicable limits. In determining the application with a view to promoting the licensing objectives, in the overall interest of the local community, the licensing authority must give appropriate weight to the steps that are appropriate to promote the licensing objectives, the representation, including supporting information presented by all the parties, the guidance issued under Section 182 of the Licensing Act, and its own statement of policy. The guidance goes on to state that licensing authorities are best placed to determine what actions are appropriate for the promotion of licensing objectives in their area. All licensing determinations should be considered on a case-by-case basis. They should take into account any representations or objections that have been received from responsible authorities or other persons, and representations made by the applicant or premises user, as the case may be. And the authority's determination should be evidence-based, justified as being appropriate for the promotion of the licensing objectives, and proportionate to what is intended to achieve. In the report, I've also detailed financial implications that a final decision made by the committee in this matter is subject to an appeal to the magistrates by any party to the proceedings. And it may be helpful for me to draw attention to the committee to the attached appendices. Appendix 1 is the application form from the applicant and the plan of the premises for the new licence. Appendix 2, as I've mentioned, is the plan of the current licensed area. Appendix 3 is a satellite image of the general area. Obviously, the railway station is indicated by the blue symbol for a train. Looking at the map and the plan, the licensing panel will be able to see the car park just to the north of the little blue train, the associated field, and opposite that the paddock, and you can make out the railway cottages to the left-hand side of the picture. Appendix 4. There are various site photos, as members of the panel may not have visited the site previously. The first view is from the car park down to the station building. The second, third and fourth views are of the car park area. The next view is the railway field from the car park, which is the same as the subsequent view. The following photographs are the railway field looking down from the top of the field towards the car park. We then have a view of the paddock area, which is marked 8 on the plan, from the end of from the station end. And then we have 2 pictures from the top of the paddock, near to the track towards the cottages, one looking down towards the paddock, and the next one looking back towards the location of the cottages. The following photographs give the panel a feel of the platform areas which are requested to be licensed. So say appendices 5 can be disregarded because that has been satisfied. The panel have at appendices 6 the full representation from Mr. Peter Clark, 7 from Mr. Adam Hackett, 8 from Miss Camilla Wetheridge, 9 from Mr. Damien Paul, 10 from Mr. Jake McQuitty, and 11 from Mr. Rufus Clark. And at Appendix 12 are the schedule of proposed conditions from the police, and I have read out the proposed ones from the Environmental Protection team. Unless I can assist the panel further, that is the matter before yourselves today.
Okay, thank you very much indeed. My first task is to actually ask, to confirm that if any of the members here wish to speak, please press the right-hand button to make that clear, and all questions are through the chair. If any of the interested parties would like to actually kind of ask questions of Mr. Bryant on his report, now is the time to actually do so. Okay, fine, thank you.
Yeah, you have no questions? No.
Fine.
To the committee.
Thank you, Right, committee. Thank you.
Mr. Bryan, could you explain a little bit about the 2012 Live Music Act and how it applies to this particular application or does not apply? Thank you.
Yes, certainly, Councillor. When the Licensing Act was first introduced, Councillor, when the Licensing Act was first introduced, it made the performance of live and recorded music a regulated activity. And that was any size of event. In 2012, the Live Music Act was introduced, and what that did, that deregulated live and recorded music under certain circumstances, and so it no longer became an activity regulated by the premises licence. If live and recorded music is played between 8 AM and 2300, 11 PM, on licensed premises with the benefit of a on-alcohol licence, and the premises is open, and there are less than 500 persons in attendance, then that performance of live or recorded amplified music is not considered licensable. There is a mechanism within the Licensing Act for that exemption to be reviewed by the licensing panel. But however, this isn't something which is under consideration now. In respect of unamplified live music, that was deregulated that between the hours of 8 AM and 11 PM, and that's at any place with any number of people. So that's acoustic music, is unregulated entertainment between those times. And again, if it was on licensed premises, if using that exemption was causing an issue and we received complaints, then it could be addressed through the Licensing Act for the exemption to be removed. But currently, those activities are not considered to be regulated entertainment under the Act between those times, if those conditions apply.
And just to clarify, we're not reviewing that now. The question I was going to ask was that one of the complainants mentions the continual playing of Christmas carols, which of course are amplified, but don't form part of the regulated. How can I put it? I don't want to preempt any of the representations or preempt any of the panel's decision, but all I would ask the panel to do is listen to the representations and the context of the representations to make your decisions accordingly on the application. Thank you. Right. There are no... Please.
Thank you very much. Mr. Bryant, when you said one of the conditions from the Environmental Protection Team was that the number of days on which events can take place to 12. Now, are we talking about 12 particular days, as in 24 hours, that's it? Or are we talking about events, as in maybe 2 or 3 days?
Provide clarity, the condition which has been agreed with the Environmental Protection Team limits the number of days to 12 days. So potentially you could have one event consisting of 12 days, or you could have 12 events consisting of 1 day. But the total number of days has been agreed at being 12.
Councillor Hembrook, do you have any more questions on that?
No.
Okay, thank you. Jason. Mr. Clark.
Just following on from that last question, does that mean that on one day there could be 2 events?
Yes, potentially, because it's the days which count rather than the events.
And just one other point. The existing licence is for the 2 fields, the field and the paddock, but not the station buildings. Is that correct? The addition is the station buildings.
The current licence is the field and the paddock, and it also licensed the refreshment room, the bar. It doesn't license any other part of the station, the platforms, or the associated buildings.
But from what you said about the objections, they're mainly to do with the paddock and the field that are licensed at the moment.
The objections that I've detailed have alluded to that, but it may well be that the interested parties may wish to add further information to their particular representation without making new ones.
Yeah.
Thank you. Right, I'm going to now invite Mr. Asa Griffiths to make his representation. Sorry, I beg your pardon.
Thank you, Chair. Sorry, just a quick question, Mr. Bryant. I just noted on the new application that the licensing was to start from 8 a.m, whereas the premises doesn't open until 10. And I just wondered, is that usual, and why would that be? Thank you.
Councillor, thank you. That is probably a question best addressed to the applicant.
So I'm happy to answer that. I think the overall application really was to provide flexibility, and changing that to 8 a.m. is just another one of those things. There are no particular events that are planned to start at 8 a.m. It's just to allow us flexibility. The same with the council over there was saying about the station buildings, etc., in addition to the paddocks. It's just, to provide flexibility that if we wanted to, for example, serve alcohol or have a band playing on the end of the platform for an event, that we could do. In the past, we've sought numerous temporary licences, and this is more of a flexible licence to be able to do those things and not to have to apply for a TENS for every event that we do. Things like food festivals, which is why the car park it was included. If people want to serve alcohol at a food festival, to allow us to do that as well.
In that case, I do have a question before I pass it on.
Chairman, shall we get them to make their submission and then we'll...
Okay, yeah, might as well, thank you. Please, go ahead. Thank you.
I'm happy to make a submission. What would you like me to say?
Whatever you think is...
I think almost everything was covered by John and is in the application. It's like I said, primarily for flexibility. The original application, we put down 365 days a year, 8 till 11. Not that we want to have a rock concert 365 days a year, 8 till 11, but we don't know what future events we might have and which days they might fall on, which is why with the environmental protection team we agreed 12 days. Another reason was that the current licence as it is states 6 events, which is vague both for us and for the licence officer, in that an event could be potentially a month long. So in a way, the new licence is more restrictive than the old licence in that we are restricted to 12 days. That's it, I think.
Thank you. Right. Mr. Bryant, would you like to ask any questions of the applicant? Okay, thank you.
I think from the railway's point of view, the current licence, as Asa stated, has a level of ambiguity that was difficult for the staff to negotiate and understand as well. And, you know, you have new staff coming in, being events coordinators and such like. And really what we wanted to do was tighten it up and make sure that everybody understood what that licence was and what we were and weren't allowed to do. In regards to the areas that we want to licence, the paddock and the field were already licensed, but we wanted to make sure that perhaps if an event we could use the newer station buildings and thus bringing things inside would actually create less of a noise pollution for our local neighbours, and we wanted to make sure that that flexibility, as Asa said, was there to choose the right location for the right event, really. That's it, really.
Would any of the interested parties, and I mean the people that made representations, like to ask questions to the applicant, please? Thank you. If you can push a right hand button. Thank you. Right.
Thank you.
Thank you.
I haven't got many questions. Just want some clarification, really. You indicated in your application that if you got the new licence approved, that you would relinquish the current licence. Is that still the case? So just so it's absolutely crystal clear, this is not 6...
Sorry, can I just stop you? Can you push your button again? Thank you. Sorry.
So just to be absolutely clear, this isn't 6 events plus 12 events. This is purely now an application for 12 days.
Correct.
Can you confirm that noise management plans have not been used in the past?
A nod or a yes will be quite sufficient. Okay.
I'm fairly certain that they have not, which is one of the reasons why we're looking into all of this. Except perhaps in the last event, the 60 plus 1 event that you referred to last year, we had environmental health did contact the railway, and our events coordinator then worked with environmental health on the complaint that he had received. So he may well have put one into place specifically at that point, but not before, as far as we know. Again, as I said before, new staff coming in, it's about tightening up, having the right records and having the right licensing in place going forwards, making sure everybody knows what they can and can't do.
Just picking up on one of the questions that was asked by the councillors, can you explain why the licence is still sought from 8 o'clock in the morning if you've no intention of actually having an event containing all the activities that you propose, starting at 8 o'clock in the morning?
I can speak for Asa on that one. I think you'll find it was a box he ticked We're not really worried about it starting at 8 o'clock in the morning. From an events point of view, quite happy with a normal licensing hour from 10 o'clock. So if you want to make that change, we're quite happy about that. Yeah. I think when the form was filled out, it wasn't necessarily done in a way, it was done with some misunderstandings about what needed to be filled out, what numbers needed to be put in. So there were a couple of errors on that, and that's one of them. That's fine, we can change that. We're quite happy. We don't need to be selling alcohol at 8 a.m. in the morning, and we don't intend to play any rock music at 8 a.m. in the morning. So, all such things.
And likewise, I see in the application. In the application, you're seeking to have the licence extended until 11 o'clock at night on a Sunday. Can you confirm that that was one of these other box-ticking exercises, or is it that you intend to have events that run until 11 o'clock on a Sunday evening?
I think in the case of a Sunday, we would require the 11 o'clock finish time only for the point of view that perhaps on a bank holiday, it might be that the licence needs to be there until 11 o'clock. But for other times, there wouldn't be events running to that time of the evening on a Sunday.
And finally, could you explain what efforts or what procedure stroke policies the Bluebell has to address complaints that are made about noise at the time of the events taking place?
Yeah, part of the noise management plan that we're putting together, which is going to be agreed with environmental protection before the first event under the new licence, states that there will be a central point of contact for the event, a mobile number given, that the residents will, of the cottages, etc., will have. Also, we have a new two-way radio system that covers the whole railway, which would make the responsible person at the railway contactable at all times.
Can you just confirm? Can you confirm that to date there hasn't been any coordination or consultation with the residents at the cottages about events?
I cannot confirm that there has not been any coordination or discussion with residents about events, as I know that they have been notified by letter prior to events of what events are coming up and what's happening in previous years. So as from your question was, can you confirm there's been none? I cannot confirm that because I know that there has been some previously. So it's not a yes, no answer.
So picking up on that point, is it right that you're saying that there hasn't been a consistent policy of consulting with residents about events, that it is an ad hoc approach?
Personally, I can't answer that in its entirety for the last 40 years of the events that have been going on there, but I know that it is a policy that has continued to happen over the last few years that I have been there, and letters have come from named persons at the railway, and they have been signed by directors or by the management of the railway and been distributed to the, at least in this instance that we're talking about, the railway cottages, the ones that we feel, you know, the most affected by what's going on at the railway. I know, from my point of view of being there the last few years, I can think back of the events that I've been part of or helped with, and I know which ones have certainly, the letters have gone out, and they have been directed by Lisa Boyle at the railway, and they have gone out. If you have a different experience of that, then I'd be happy to address that for you and take that forwards back to the railway and get that sorted out. no problem.
Thank you very much indeed. Councillor Cornish.
Thank you. Thanks, Chairman. Actually, my question follows on from the interested parties question about notifying residents, and I just wondered what would be an acceptable time period to notify residents of an event. Well, I'm asking you what is the case, or what should be the case when notifying residents, just because if there are 12 days of activities planned, then we have discussed advising residents of the cottage. So I just wondered what is in place to notify residents, and is there a timescale that would be in place?
I think one of the conditions that the police asked for was that for large events they would have no less than 12 weeks' notice. So yeah, I would suggest a similar. If we're notifying the police, we can notify the residents as well at the same time.
Thank you. I'm going to come back to Mrs. Clark in a minute. I do have a quick question regarding the setup and the timings that emerged earlier as a question regarding the start time of 8:10 in the morning. Have you considered, if you have an event with amplified or music or etc., setting up for a band, that even though if the licence started at 10 and you amended and the times were amended, you wouldn't be able to actually start off playing until the actual, effectively, the equipment's set up. So you'd need time. And have you considered that?
Yes, we have considered that. For example, I'll give you an example of the event that we had last year. We had a 60th anniversary event, delayed one, and we had music over 3 days. And on the 3 days, the bands did not begin until 12 o'clock midday. So there's the setup time in the morning, or perhaps some sound checking from about 11:30, but they're not playing first thing in the morning. I mean, to be fair, any event, you don't have your attendees really getting there until about lunchtime anyway. So anything we do, we try to keep it around the core time that people are actually going to attend.
Okay, thank you. Mrs. Clark, you were asking to speak.
I don't have anything else to ask, thank you.
Okay, fine. Thank you. Councillor Henwood, please.
Thank you. I'm just curious, last year or in the recent history, what are your most popular, most frequented events?
Are we talking specifically about large events over 500 people? Very little. We don't really run very many. We've had one last year, which was our, as I said, the 60th anniversary with music and such like. It is possible that if we had a gala that had a lot of pull for the enthusiasts, that we might get a few of those around. And it is over 2 days last year, we had 2,500 people visit the whole of the railway for our Road Meets Rail event. So I wouldn't think there was even 500 people at one time at the station, at Horsted Cane Station particularly. We just want to make sure that we're not exceeding, going into licensable activities by having it. If we're talking about Santa is also very popular. We were talking about this earlier. You mentioned it earlier. That is probably the railway's biggest earner for the year. Forms part of a major part of the income. But that is still under 500 people at any one time. So really, Well, those are our biggest events.
Just clarify.
Mr Clark.
You mentioned that the police are looking for 12 weeks' notice for events over 500 attendees. You've indicated that most events are smaller than that. So would it be actually possible to give 12 weeks' notice to the local residents of every such event? Would a shorter period be more practical?
I'm afraid for some events a shorter period would be more practical. The ones that we know are coming up further along in the year and we know they're going to be cited at Oyster Canes, most certainly. And I think, you know, we can go away from here and we can make a policy around that, which the events coordinators can have, with a recommendation that they give 12 weeks notice. But as you say, more practical, I'm not going to say the word, but more relevant for smaller events, it probably is a shorter notice period. Maybe difficult to say, a month would probably be more. Because then you've got a bit more of the detail of actually what that event is going to entail, and more of an idea of numbers and the kinds of contractors or such like that might be involved.
Okay.
At the end of the day, you know, it's a commercial operation, and if an opportunity presented itself that we could run an event, you know, with shorter notice, then we'd look into that. But yeah, so less than 12 would be ideal for some events if things were presented to us that could work.
Okay, thank you. Right, any more questions? Right. Mrs. Clark, I think. Yeah. If you, that's it.
Hi, sorry, can I just ask why we only got 1 week's notice for the event that's happening on Monday?
That shouldn't have happened. And our discussion here about putting something in policy, we'll make sure that doesn't in the future.
Thank you. Right, I'm going to move on to Mrs. Clark's presentation now, if we may. Thank you. Thank you.
I think, Councillor, you'll be pleased to hear that quite a lot of what I was going to say has already been addressed, so I'm not going to trouble the panel with everything that I wanted to say. I just found my notes. There are just 3 points, really, of amplification I'd like to make on behalf of my husband. The first one is the location context, and I think it's important that you and your colleagues understand where the location is and why it's important, and really why it sort of underpins the complaints that have been precipitated by this application. I know Mr. Bryant has already taken you to the various appendices, but could I take you back to appendix number 2, please? The diagram, as you will see, is hand-drawn and it's not to scale. The cottages are numbered 4, and from the diagram it appears that there are just 3 households. That's not the case. There are in fact 6 households contained within 3 buildings, but they're semi-detached cottages. So this is something that is affecting not 3 households, but 6 households. The distances, likewise, are not to scale. The distance between the cottage on the furthest left-hand side to the edge of the paddock is approximately 20 paces, 10 metres or so. The distance between the cottages and the field, which is annotated number 5, it is further away and it is across the cut. But as the crow flies, that's probably no more than 50 or 60 metres. So we're talking about locations that are very, very close to where we live. If you look at the next aerial view, which is the next appendix, which is appendix 3, the aerial view, the cottages are almost slap bang in the middle at the top. You can see the three buildings there on the left-hand side of the track. All that that is between the end of the cottage and the paddock is a tree. The garden of number 1, that's the first cottage that you can see there, shares the boundary fence with the paddock field. And if you can see where going up towards the north, the track takes you to a 90-degree bend which goes over a railway bridge over the cutting and then takes you back up onto the field. Whilst events on the field themselves, and indeed the car park, which is further to the south, just above where the little blue train is, we're not troubled very much by passers-by. The noise from certainly the events in the field and the car park do travel because the track itself is set down at the bottom of the valley floor, and the land to the east and to the west rises slightly. The gradient, if one looks at the OS map, which was attached to the application, I'm not quite sure what page number that is, but there is a photocopy of the OS map. Do you have that? Yes. You can see on that extract from the OS map of the local area that Horsted Keynes Station is towards the south, and there's a red circle. And you can see that the track goes up almost south to north. The contours to the west and to the east, if one follows them down, whilst the actual contours aren't particularly steep, they do actually produce what you could perhaps describe as a natural amphitheatre. So when there are noises at the station, the sound is funneled down the track until it gets to where the land expands, just beyond Cinder Hill, where it's marked there. And, in fact, where Mrs. Witheridge's house is at Horsted House Farm, which is right at the top where the steam train logo is, on the right at the top in the middle of the page. By the time it gets to Mrs. Witheridge's property, the sound is actually reverberating across the whole of the valley, which is widened out. So those of us that are caught in that narrowness, the noise, there's nowhere for us to go. The noise at times does, in fact, make the windows reverberate. I can't speak for those that live to the east or to the west on the higher ground, but certainly the panel will have seen the complaints made by those residents in respect to that. So that is one of the points that I would wish to make on behalf of my husband, that the actual location of where we are is significant, and that does contribute to the nuisance that we experience when such events take place. Secondly, the other matter that I would like to raise on behalf of my husband is that the timings for the extensions, the timing extensions which have been sought. Just going back briefly to the residents in the cottages, if I may, there are 6 households. 2 of those households have elderly and frail residents, and indeed cottage number 1, one of the residents is 8, the other one has serious disabilities, and both of them are frail and vulnerable. You will have noted that from what Mr. Bryant said, that there were 2 additional representations made. One of those that was deemed not relevant was in fact from that couple at cottage number 1. So they've complained. The other couple at the other end of the cottages, they too are elderly and frail. The other 3 there are 3 other households which have individuals who are working there and one with children, and include shift worker. And the remaining property that I've mentioned is a family who are connected to the Bluebell and who wish to remain neutral and not got involved. So out of those 5 residents who are wishing to be involved, 4 have made representations, and therefore it's my submission that the majority of the residents at the cottages have significant objections to be made about the extension of the licensing that the Bluebell have sought. I am not clear, moving on to my next point, I'm not clear about whether or not the licences, whether or not the Bluebell have agreed that they are not seeking a licence from 8 o'clock or not. if they are still pursuing the licence to start at 8 o'clock in the morning, my submission is that everything that you have heard does not assuage any of the fears about unreasonable noise so early in the morning. The test that you have to be satisfied of is the likely impact on us of the events, and in particular I'm focusing now about starting at 8 o'clock in the morning. Again, this is an application for 365 days a year. Doesn't make any distinction between weekends or work days. And the likely impact on us, if these are allowed to start at 8 o'clock in the morning throughout the week, are going to potentially have an impact, particularly on the shift worker, when they come home early in the morning after working all night and cannot get to sleep during the day, or have to go to bed early in order to get some sleep in before they go to work in the evening. So on that basis, we object to the start time being 8 o'clock. If it was 10 o'clock, I think the issue would not be quite so problematic for us. The end time of 11 o'clock for every single day of the year, again, I make the distinction between work days and weekend days. I understand the point that is made by the Bluebell that if there is a bank holiday weekend, that the end time should be 11 o'clock. But my submission is that it should not be a blanket extension of the 11 o'clock end time, and that if there are events that need to be that take place over a bank holiday weekend, then there needs to be a further application made to extend that time limit. The other point that I'd like to make about the noise that emanates from the events, and hitherto the events that have taken place in the paddock and on the field, or on the car park, as it is now hoped to extend it to the car park, they've taken place in marquees. This year it appears that the Bluebell have got some very nice brand new awnings. They're not tents, they haven't got sides. That doesn't make any difference whatsoever to the volume of the noise, or indeed to the spread of the noise. There is nothing that can contain the noise that is being made. For example, if, as the Bluebell have suggested, that events are taken indoors, that will make a significant difference to us, because the actual solid walls of a building will absorb the noise, and it's not going to necessarily trouble us. But at the moment, all the events are outside in a tent, so there's nothing between us and the noise that's being made. The other thing to bear in mind is that these events predominantly take place in the summer. So from Easter until the children go back to school at the end of the summer holidays, this is where the events are concentrated. The difficulty with that is that, first of all, it's hot, usually in the summer months. One prays for it being hot in the summer months, which means that, and our houses aren't air conditioned, so the windows have to be open. The noise means that we can't have the windows open. We are so close to the events that it makes sleeping very difficult. And I believe that's one of the points that's been made by one of the other interested parties. The second point is, of course, that in the summer months, we like to enjoy our gardens. We live where we live for a reason, and that is because it's beautiful. We have no objections whatsoever to the steam trains. That's one of the beautiful things about living where we do. It's the ancillary events that cause the problem. The recorded music, the amplified music, the live bands, etc. Because we cannot get away from them. So, for example, if we wish to use our patio in the evening, we are competing with the noise from the field or the car park. The other matter that is tangential to that is the noise from the attendees when they are leaving. So the actual music itself and the band will stop at whatever time it is. But then it takes probably about 45 minutes to an hour for the people to disperse. So we have to listen to shouting and singing Usually the individuals have been drinking alcohol as well. Car doors slamming, engines revving. And that's in addition to the event finishing at either 10:30 or 11 o'clock. So it's not that the noise nuisance stops at the moment the music stops. It carries on for an additional hour or so thereafter. And that has an impact, particularly on a Sunday night, on those of us that have to go to work. Another minor point, and that is that certainly since COVID, I've been working from home. And I understand there's one other resident who works from home. And certainly in the summer months, my house is extremely hot because of the orientation of the property. I don't want to have to sit in my office with the windows shut and be absolutely sweltering because I can't hear myself think because of the noise that's emanating from the Bluebell. I don't need to address you about the number of events and the definition of events because that has been addressed, and I'm grateful for the Bluebell for clarifying that. My final point is that the Bluebell is a beautiful place to live, but it is blighted by some of these events because there is a lack hitherto of any real grip on what is going on. Complaints are dismissed out of hand. As residents, we are treated as if we are the enemy. We wish to work with the Bluebell. We're neighbours. We need to get along with each other. There has been no communication or no effective communication. The notification we received for the event this weekend, which is a 3-day event, Saturday, Sunday and all day Monday, we only received a letter on Tuesday of this week. That, in my submission, is unacceptable. In any event, we knew there was an event coming because we'd had to listen to the vehicles going past the bottom of our gardens for the past 3 or 4 days before we got the letter. But communication is key, in my view, speaking for myself and my husband. And if the communication channels can be opened up and that we are treated as residents with some respect, and that the complaints that we made treated in a constructive way, I have no doubt that the situation that has arisen here today could have been avoided. If the noise management plan is to be drafted, I am also grateful to the Bluebell for indicating that a named person with contact details will be made available. That will make it significantly easier to communicate. But I would also urge the Bluebell to recognise that not just do we need a named contact and a telephone number, but we need somebody to be proactive and to listen to what we have to say and take us seriously, not dismiss us as just being cranks or nuisances ourselves. We're not there to be difficult, but we do have to live there. And those people that create these events, they can go home at night and be quiet. We've got to stay and live with it. Those are the points that I wish to make. I have nothing else to add.
Thank you very much indeed. Mr. Bryant, would you have any questions? Please.
No, Chair, I've got no questions.
Thank you very much indeed. Would the applicants have any questions? Okay, fine. Thank you very much indeed. Councillors? No. Any of the other interested parties in the room? No? Okay, fine. Thank you very much indeed. In that case, we will move on to Mr. Damien Paul, please. Thank you.
I've nothing further to add. I concur with my neighbour, and I'm happy that Mr. Bryant succinctly put all my points across. Thank you.
Okay, fine. Thank you very much indeed. Any questions emerging from that gap? Okay, fine. Thank you very much indeed. Right. Could the applicant, can you sum up, Mr. Griffiths, please?
Yes, so I think we've shown that with with this new licence, we're already licensed under the current licence for a number of things. The new licence is seeking to more clearly define what is allowed and isn't allowed, between which times, and we are very happy to change the 8 o'clock start time to 10 o'clock. That's no problem. I think I was, when filling the form out, following on from the previous licence for alcohol. So, same times for all the activities. We are also quite happy to put in place a plan to notify the neighbours within reasonable time period of events that are likely to impact them, in addition to the other compromises and agreements we've made with environmental protection regarding the noise management plan and the police, etc.
Thank you very much. I'm going to, before I pass over to Councillor Henwood, while you're on the microphone, you've indicated earlier that you only need 2,300 hours on event days. Is that correct? And if that's, or do you need that every day? And if that is the case, what would the time that you need be for the days that are not event days?
Can I ask, is this specifically for live music or is this for alcohol?
Give me an answer for both.
I'd like to be able to serve alcohol until there is a bar there, which is currently a licensed bar. So it would be nice to be able to serve alcohol. For live music, I'm happy for that to remain until 11 o'clock, but on those 12 days, as agreed, and subject to the noise management plan as well.
Thank you very much indeed. Councillor Henwood. Thank you.
It's not just frivolous, but you might consider offering to your nearby residents free passage for appropriate events. You do? Okay, thank you. Well, obviously communication is essential. Thank you very much.
Thank you. Any more questions? Okay.
Clarify what they've said to your, what they said to your question.
Thank you. Right. And so I'm going to clarify the answer to that question, is that the applicant would cede the start time from 8 till 10 on a daily basis, and that the termination period is for 2,300 hours, irrespective of whether there's an event or not. Okay, fine. Thank you very much. Over to Mr. Clark, then, please. Thank you. Yeah. So as there are no more questions, the panel will withdraw, and we'll be back as soon as we can. Thank you very much. Right, we'll resume the meeting. I'm going to hand over straight to Mr. Clark. Thank you.
Thank you, Chairman. The panel are minded to grant the licence, subject to the additional conditions in Appendix 12, but they amend Condition 2 to include notification of the residents in addition to the licensing authority and the police. And it's subject to the following changes as well. The licensable activities shall not start before 10 a.m. on any day of the week. The licensable activities on a Sunday shall finish at 22:30, except where the following day is a bank holiday or public holiday. And the licensee should seek to give 4 weeks' notice of all events with up to 500 attendees to the residents.
That's it. I have no further business. I'm going to close the meeting at 15:35. Thank you very much, everyone.